the lecture, or call it essay, or call it what you will, which you can download or upload. I'm not very good at high tech. I've called it the Pathfinders. And I'll tell you in a moment why I call it the Pathfinders. It deals with two very eminent judges that we have had of the Supreme Court, Chief Justice Subba Rao and the great Justice Krishna Iyer. And I've called them the Pathfinders because at this time of year, this is Christmas time, in the northern hemisphere, there is a constellation which you will find on a clear sky visible. Astronomers call it the Ursa Major. More popular, it's known as the Great Bear. The constellation includes 7 bright stars, and in Indian astronomy, these stars represent or are said to represent the 7 rishis, the Sapta Rishis. But 2 of them alone are the pointers. They point to the pole star. And that's why they are called the Pathfinders. Now, in the judicial firmament, or in the courts, if you like, these past 72 years, there have been many bright and brilliant stars. But the pointers, what I would call the Pathfinders, have been few. I'll here only name 2, Chief Justice Subba Rao and Justice Krishna Iyer. They are the subject of this piece or lecture or essay. Judges other than Subba Rao and Krishna Iyer have written judgments, lucid, learned. Some of the judgments of our first judges of the Supreme Court, Justice Vivian Bose, most eloquent of the judges, Chief Justice Das, and the versatile Justice Gajendra Katkar, they adorn the law reports when you go through them. And it is a tribute to these giants, let me call them, that some of their judgments are still read for instruction and pleasure. But the 2 pointers, the Pathfinders, Subba Rao and Krishna Iyer, were different only because they influenced creative judicial thinking in other justices, and they lighted up new and difficult and different paths which others followed. Subba Rao and Krishna Iyer were 2 outstanding examples of judges who in different ways influenced and altered the habits of mind of the judges. The judges of my time, the 1960s, the 1970s, and the 1980s. And I hope that they will continue to influence and alter the habits of the minds of present-day judges and future judges as well. First, about Subba Rao. The influence of Subba Rao began with his appointment as a judge of the Supreme Court way back in January 1958. As a puisne judge, that means a judge other than the Chief Justice. And you will find that if you read his judgments, he was also its most frequent dissenter. What is now known as the Subba Rao era only began with a short but vigorous tenure as Chief Justice from June 66 to April 67, just 10 months, when he resigned. And the reason he resigned was to contest unsuccessfully, as it turned out, to the office of the President of India. Presiding over the Constitution bench in that brief period of 10 months as Chief Justice, he handed down decisions in as many as 62 different cases, almost all important cases, constitutional cases. And I have referred to and discussed the leading cases amongst them in this lecture. 60 of the 62 judgments delivered by the Constitution Bench, presided over by Subba Rao, in that brief 10-month period when he was Chief Justice of India, was unanimous. All that is to say, it was delivered on behalf of benches of 5 and 7 and sometimes 9 judges. It was a rare example of firm judicial leadership. Those who sat with him have frequently confessed that they were not only impressed by his ability and intellect, they were also greatly moved by his innate courtesy. He was absolutely a courteous judge, and his keenness to persuade. The impetus for change, after all, depends on personal persuasion of someone who is accepted as a respected colleague. The influence can never be lasting if it is obtrusive. Subba Rao was never obtrusive. And persuasion is the more successful when it creates an atmosphere receptive to change. And Subba Rao, both as judge and then as Chief Justice, created that atmosphere. An earlier Chief Justice, Justice S.R. Das, very distinguished, on his retirement in September 1959, made a very amusing farewell speech which has been published in the law reports. About Brother Subba Rao, as he put it, he was particularly jolly and jovial. After referring to some of his other colleagues, also in lighter vein, he said, and I quote him, "And then we have Brother Subba Rao, who is extremely unhappy because all other fundamental rights are going to the dogs on account of some misconceived judgments of his colleague, which require reconsideration." In all spheres of the law, particularly matters pertaining to constitutional law, he was the one who was most articulate. And the serious bit about this piece of frivolity of Justice S.R. Das that I just quoted was that Brother Subba Rao did sincerely believe in what he was later to describe as the transcendental nature of fundamental rights. He genuinely believed that many decisions interpreting various provisions in Part 3 of our Constitution in the first decade of the Supreme Court, in the 1950s and 1960s, up to 1960, they were retrograde. And during his 7 years on the bench, more than 6 of them as a puisne judge, he did his utmost to undo them. In the early years when he couldn't, he dissented. In later years when he could muster a majority of judges for his views, he affirmed his previous dissents, which happily then have become the law of the land. In all spheres of the law, particularly in matters pertaining to constitutional law, he was rarely content with joining the majority opinion. Even when he concurred with the majority, he expressed his own view. The number of his concurring opinions are well above the norm. He wrote the largest number of dissents ever in the Supreme Court. Judgments in as many as 49 different cases, he dissented from the majority. Contrast this with 6 justices of his time who never wrote a single dissent, and another 6, each of whom contributed only a single dissent. The clarity and quality of his judgments bear testimony to his great impact on his colleagues. Justice J.M. Shellert of the Supreme Court once said to me after his retirement that both he and Justice J.C. Shah were greatly influenced by Subba Rao. His concern for fundamental rights and his distrust of parliamentary majorities led to some of the most controversial decisions, which you will read about in the essay. He was someone who abhorred absolute power, especially the arrogance of absolute power, whether exercised by an executive administrative agency or even when exercised through the legislative process. And he did not stop short even at questioning the validity of the exercise of constituent power, that is, constitutional power, which he did in a masterly manner in Golaknath, that celebrated case where for the first time 11 judges sat all together to decide a case of constitutional law. This was way back in 1967, where I had the good fortune to appear as counsel. The other great stellar pointer in the judicial firmament, and we now go to Krishna Iyer, he was responsible for and in turn inspired a new thrust, a new direction to the Supreme Court, because he helped to humanize the legal system, particularly in the field of criminal jurisprudence and jail reform. He extended the frontiers of the accountability of the state and its instrumentalities in their ever-expanding operations. And he often strayed from the beaten path of the law, spinning what is known as his own cocoon of jurisprudence, inspired by the fact that in dispensing justice, the answer to the question, what result is best for the country, is not always consistent with the response obtained by asking, what is the decision according to law? He therefore treated, and so inspired other judges to treat, even binding decisions of the court as no more than decisions applicable to the facts of that particular case. To attempt an assessment of Justice Krishna Iyer through his judgments, as in the case of Subba Rao, is not a correct approach, because this judge, more than any other of his time or even later, by his wordy and sometimes seemingly irrelevant judgments, made other judges think. Even when he was writing a majority judgment, he made provision as if it were a minority opinion for what is known as the brooding spirit of the future. In a scholarly article which I read some time ago, the author of it asked, what is the point of a judgment that includes passages which are on the judge's own admission irrelevant? And the answer was that there are diverse audiences to whom judicial opinions are addressed. Some judges in their judgments are constantly explaining their decisions to litigants and their lawyers and to succeeding generations of judges. And so it was with the judgments of Krishna Iyer. He is the originator in Indian jurisprudence of introducing into judicial pronouncements what is now known as the purple patch. It is not uncommon with some judges. The phrase purple patch has been explained by the great Lord Denning, and I'm quoting him, when you are covering a garment, when you are covering, as with a garment, some weighty or important matter, you should sew on one or two purple passages so as to attract the attention of those who are unfamiliar with it, which is a good tip for all judges. Krishna Iyer's judgments are strewn with what are known as purple patches. He made no secret of the fact that a judge must have a social philosophy and, above all, a humane approach to legal problems. While Subba Rao had an obsessive concern for fundamental rights, Krishna Iyer's concern was broader. His kind heart almost bled for the poor and downtrodden. He carved out a special entrance for the poor and destitute in the formidable portals of our Supreme Court. Along with Justice Bhagwati, who also was a very influential judge in the Supreme Court, he gave a new dimension to the range of 8 or 10 or 15, I think, articles in Part 4 of the Constitution, which is known as Directive Principles of State Policy, which had hardly received much prior attention from the court. And then Krishna Iyer had that abiding quality of a great judge. He was fearless. And I'll tell you why I say he was fearless. While still a junior judge in the Supreme Court, just 2 years from his elevation from the Law Commission to the highest court, he was not a judge in the High Courts. He was only a very prominent person in the Law Commission. He had to sit, and he sat as a vacation judge during the summer recess of 1975, one of the most critical periods in Indian history, that is India's judicial history. Prime Minister Indira Gandhi had lost the election petition filed against her by Mr. Raj Narayan in the High Court of Allahabad. The High Court judge ruled that she had forfeited her seat in the Lok Sabha and she sought an absolute stay of the judgment and order. The matter was argued in the summer vacation before Justice Krishna Iyer, the vacation judge. He could have passed the buck, granting an absolute stay till the reopening of the court a few weeks later, when a bench of 3 or 5 judges could have finally heard Mrs. Gandhi's appeal. But he did not flinch. Sitting singly and taking the entire, as he was entitled to do in the vacation, otherwise judges are minimum 2 or 3 or 5, sitting singly, taking the entire odium on himself, he passed an order strictly following precedent and granted only a limited stay to Mrs. Gandhi, consistent with the past practice of the Supreme Court in all election appeals. He ordered that whilst Mrs. Gandhi as Prime Minister could speak in either House of Parliament so long as she held that office, Mrs. Gandhi as a Member of Parliament could not vote nor participate in proceedings of the Lok Sabha because she had been unseated by the judgment of a competent court. Years later, when I came to know him well, I would once in a while pull his leg and tell him that it was his vacation order that really brought on the internal emergency. India's constitutional historian, Mr. H.M. Silvai, who was otherwise very critical of Justice Krishna Iyer and of his judgments, had this to say, and I quote, "In the best traditions of the judiciary, Justice Krishna Iyer granted only a conditional stay of the order under appeal, although he had been reminded by her eminent counsel, Mr. N.A. Palkiwala, that the nation was solidly behind her as Prime Minister, and that there were momentous consequences, disastrous to the country, if anything less than a total suspension of the order under appeal were made." That was Palkiwala's submission. Great praise, indeed. But then Krishna Iyer always did what he thought was right and never bothered about the consequences. So my friends at the bar, do remember that every judge carries with him his biases and prejudices. What Justice Holmes, the great Justice Holmes of the US Supreme Court, used to call his can't helps. So with Justice Krishna Iyer and the adherence to his school of, to those who contributed to his school of thought. He always believed that the assertion made in the United States that the Supreme Court is a political institution applied as much to India as to the United States. Law without politics is blind, he once said. Politics without law is deaf. He would rather do justice overriding law than administer what he believed was injustice according to law. After retirement, he had said, and I quote, "The myth is that courts of law administer justice, but the truth is that they are agents of injustice." He thus widely influenced some judges to do justice according to their whim and fancy, in disregard of law. And in this, I believe, he did a great disservice to the adherents of his school of thought. Because some judges, as you will see from their judgments, who succeeded him, attempted to ape his style and use four-syllable words where even one would do. But such persons have failed to realize that Krishna Iyer always regarded language as a convenient vehicle for ideas. And if the manifold ideas in his very fertile brain could not be expressed in known language, he had no hesitation in inventing words and adapting English words to suit what he believed were Indian conditions. So in one case, he famously said, and this judgment is reported, and I quote, "Is Rashtrapati Bhavan or Raj Bhavan an Indian Buckingham Palace, or is it a halfway house between Buckingham Palace and the White House?" Such imagery is inevitable, expected of Krishna Iyer, but I must say it is intolerable and ludicrous when it is attempted by someone else. People who attempt to ape him do not realize that his penchant for long words was not a studied exercise. He spoke in court in the same vein. I once heard him deliver judgment in courtroom number 3, where he sat. An oral judgment, a judgment off the cuff, where amongst several multi-syllable words he used one with 6 syllables. Ratiocination. Ratiocination. There were many litigants and some lawyers present in court that day. Half of them, I'm sure, could not pronounce the word, and most of the others did not know what it meant. Krishna Iyer had been and was a mixed package, packed to the brim with a mixture of much law, of some politics, but of abundant common sense. But above all, of compassion. When on the bench, he always reminded me of Lord Denning, England's great master of the rolls. When counsel once urged Master of the Rolls Denning not to invent a new head of policy, Denning responded, "I know that public policy is an unruly horse, but it is for an able and competent judge to ride that unruly horse and to bring it down on the side of justice." In the course of his judicial career, Justice Krishna Iyer gladly rode unruly horses. In fact, he even looked for them. He showed considerable prowess as well as ingenuity in bringing them down on the side of justice. Though I must say, at times, after the ride, the fences of the law needed also some mending. The new sites he fixed for the highest court are epochal. The new trends of thought remain long after he retired. In fact, without ever having the authority of a Chief Justice, he left his mark on the decisions of the Supreme Court of the 1970s, the 1980s, and they had a distinctive stamp. They were the judgments of what is now known as the Krishna Iyer era. It is well to remember that it is a time difficult and sometimes dangerous to emulate a person when you cannot hope to be. As Dr. Johnson once said, almost all absurdity of conduct arises from the imitation of those we cannot resemble. So there are dangers in saying and doing all that Krishna Iyer said and did. Krishna Iyer's record of judgments in sheer numbers surpasses that of Subba Rao. In his term of over 8 years in the Supreme Court, Subba Rao participated in over 560 cases in which judgments were delivered, himself delivering 254. During a shorter period on the bench, a little over 7 years, from July 73 to November 1980, Krishna Iyer participated in over 700 cases in which decisions were rendered, he himself delivering judgments in more than half of them. In Australia, there was a famous judge called Chief Justice Latham. He used to say that when he died, they would find engraved on his heart, Section 92. Now, Section 92 is the Trade and Commerce Clause of the Australian Constitution. It inspired very much a lot of litigation at the time, all of which he had to deal during his tenure as Chief Justice. Despite the fantastic progress of science, of particularly medical science, in the past 2 decades, there has not yet been invented a cardiac machine which could have read what was written in the heart of Justice Krishna Iyer. If there was such an instrument, one would have read the words, legal aid. In fact, it was he who gave a new meaning to the equality clause in the Constitution, that is to Article 14. When a US judge, Justice William Douglas, who is the longest serving judge of the US Supreme Court, retired, after a tenure of over 30 years, a magazine described him as the court's grandest maverick, a rugged liberal with a shock of white hair, piercing eyes, and a luminous regard for the First Amendment. If you substitute for First Amendment, which we don't have, the word poor, the description aptly fits Krishna Iyer with his shock of white hair. It has been sometimes said that Subba Rao and the Subba Rao court was rightist, and the Krishna Iyer and those of his school are leftist. But this is a superficial characterization. It is only indulged in by those who are obsessed with isms. It is not even correct. Each had many similar and abiding concerns. The abiding concern of the Subba Rao court were underlined coincidentally but characteristically by both the first and the last case in which he presided as Chief Justice. You will read about it when the entire lecture is uploaded or downloaded. I'm not very confident of this high tech. But the abiding concern of Krishna for human freedom was no different for Subba Rao. But do remember, these two judges had their drawbacks, and this is also mentioned in the essay, which only goes to show that in the end judges are human beings, and that human beings, like stars in the firmament, also have their blemishes. But despite such blemishes, they shine. And it is to the credit of these two great men, two great judges, that after taking into account their frailties, their weaknesses, they shine, and shine brightly, like the two pointers in the northern sky, the Saptarishi. Thanks.
Subscribe to our YouTube channel and click the bell icon.